I'm Professor Jocelyn Hardrick, and I'm here to provide some helpful hints for writing in the IRAC format. So why use IRAC? We're going to go into what IRAC stands for in a minute, but let's really talk about why it's essential. To succeed in legal research and writing, you need to master a writing format that the legal world has come to expect. So whether you write a memo or a brief or a proposed order, some form of IRAC will be used no matter where you work or study. And the nuances of the format will vary based on where you're working in your law school. But this guide is meant to assist you in that very basic format, because if you can master the basic format, then you can play around with it and make it more nuanced and more interesting. But what I've found in 5 years of being a law clerk for federal judges, reading hundreds of motions, helping draft proposed orders, is that people fail to use IRAC, even experienced attorneys, and there's lots of reasons for that. You have to learn it, master it, and then make it a habit. So what is IRAC? It stands for Issue, Rule, Analysis, or Application and Conclusion. It's a methodology that represents these concepts. So when you're looking at I, the issue or the legal matter at hand, you really have to frame it. You have to tell me, as the reader, what is the issue? Because typically what you're looking at is a bunch of facts. And so you got to tell me, based on these facts, here are the issues I've identified. It's also called issue spotting, so that we can decide how the rest of the discussion should go, or the legal writing. Rule means the rule that's expected or the legal outcome. So the rule is something you may also have to frame. Sometimes the rule is already decided for you because it's a statute or a rule of procedure. Other times it's something you have to create based on case law because it's not clear what the rule is, even if a statute is involved. Sometimes they are interpreted to be applied in a specific way that makes the statute functional or constitutional. And so you have to advocate for what particular rule should govern the facts and the issues as you have framed it. The analysis or application. So when it's application, particularly in law school, you're just taking the facts and applying it to the rule. Sometimes it is that straightforward, but because it seems obvious, that doesn't mean you should skip it. A lot of students are like, oh, I thought that was obvious. I'm like, it was, but I'm not going to assume that you knew it was obvious. You need to demonstrate that to me in your writing. So whether it's some kind of written assessment that you hand in or an essay on an exam, always apply the facts to the rule even if it appears obvious. Other times it requires an analysis. You have to go into the explanation of the relevant laws in the case law, and you have to sometimes provide an answer, but it's a little different than a conclusion. And so you have to say, on the one hand, you can argue this, on the other hand, you can argue that, and in your conclusion, you will say, here's a summary of my legal analysis. Based on these issues I've spotted, the rule I've identified, my application or analysis of the facts to the rule, here is the conclusion that I draw. And it's important that you have some conclusion. It may not be right, but it should flow from your issue spotting and from your rule statements and from your analysis. It should be logical. A lot of students will just kind of jump to one conclusion. You're like, based on what I read earlier, I thought you were going to go the other way. What happened? They said, well, I didn't think it was right, so I just went the other way. Okay, well, you have to match up your issue, rule, and analysis then to match that conclusion. And you should have written it the other way. And so that really reflects uncertainty. We need to sense certainty from you in your writing. And sometimes it isn't crystal clear, but you have to pick a side and advocate for it. It's as simple as that. Students sometimes are afraid to do that. And so don't be afraid to do it. And if you're not sure, write it both ways and see which ones appear to make more sense to you. Your first draft doesn't have to be what you hand in, right? Even on an exam that's timed, if you have some time to review your essay, go ahead and review it quickly, especially looking at things like your conclusion and making sure it logically flows from the rest of your discussion. If it is something that is take home, then definitely don't hand in the first draft. It's going to require you to look over it a few times. Just the facts, ma'am. So, though there's no F in IRAC for the facts, the facts section is instrumental to all IRACs. So if you're writing a memo or brief, you'll need to summarize the most important facts of the case. And this is hard for a lot of students because issue spotting and other legal analyses often take some time to master, and so students tend to write too much when it comes to the facts. And some of them write too little. And some people literally just regurgitate the facts and call that analysis. That's not analysis. I need you to take those facts and draw some inferences and apply it to the rule. Tell me why these particular facts matter. But first, you have to identify those relevant facts. So this is going to take practice, just like the other parts of IRAC. Here are some pointers to keep in mind. Remember the 5 W's and an H from elementary school, the who, what, where, why, and how. That's pretty much what you're doing here with IRAC. You're trying to identify those different parts of the story that you're going to tell with your piece of legal writing. So if it's not a clarifying detail, it's probably safe to leave it out. You don't, like, again, you do not have to just regurgitate all the facts. Sometimes some facts are added to make it a story, make it flow, make it seem a little more logical, to connect the characters or connect some dots in the storyline. Make sure all the facts you plan to mention are in this section, this fact section. So a lot of times students will introduce a new fact in the conclusion or analysis. Legal writing blunder. Don't introduce new facts because now that might have changed which rule applied. And I'm like, wait, well, how does that change everything I've just read? Tell me up front what all the facts matter for this particular section of the legal writing. And if for a longer piece like a memo or brief, all of that needs to be in the beginning. I'm sure you've learned that in your legal writing courses, whether it's in law school or even after you graduate. Keep your paragraphs short. Too much content in one paragraph just makes it hard to read. Think about those textbooks you read. Even now, the modern textbooks still have these really long, complicated paragraphs, and how hard it was for you to get through it. It wasn't just that you weren't used to it. It's not just that it's a law book. It's written in a way that's difficult to get through. So don't emulate that. Keep your paragraphs short and to the point. And you can write the facts section first. But always go back and read the facts. Make sure you've completed your analysis, and make sure that you've addressed the most important pieces of the facts and the points. So you can, again, this is part of the editing and revising process. You don't have to just give me your first draft. Keep it simple. So there's this great scene from the movie Philadelphia. It's an older movie. It has Tom Hanks and Denzel Washington, as you can see from this screenshot. He looks pretty young, right, Trin? So in it, he plays an attorney. Tom Hanks is also an attorney who was fired from his job for being gay. And, at that time, it was not a protected class. And this year, it's still not a protected class. But he also accused his firm of firing him for being HIV positive and having AIDS. So this movie is a little dated because this is before they had cures, before they truly understood how it was getting passed around. There was still a lot of stigma attached to AIDS and HIV. There is still some now. But when Tom Hanks comes to Denzel Washington, the differences between the two lawyers are clear. Denzel Washington's character is, a personal injury lawyer. He owns a little shop. He comes in, people slip and fall, accidents, those kinds of things are the typical cases he handles. He's happy doing it. He makes the amount of money that he likes, doesn't have to work all these crazy hours, living a good life as a lawyer. Tom Hanks, on the other hand, is at some big fancy law firm, making lots of money, working long hours, private country clubs and fancy vacations, etc. But he's also a closeted gay man. He doesn't have a family, so he doesn't have kids, so all his money can go to him. He has a higher economic status than Denzel Washington's character. But at the end of the day, there he is in Denzel Washington's, little mom and pop shop law firm, asking him to represent him in a suit against this powerful law firm. And so Tom Hanks's character is telling his story. He's going on and on about this incident that he occurred and how he used to just kind of grin and bear it whenever he heard horrible jokes about homosexuals and the biases that his colleagues and partners held. And Denzel Washington just says, hold on, tell it to me like a 2-year-old, right? Keep it simple. So graders, either your professors or on the bar exam, and when you become an attorney, writing for judges and clients and partners, they want you to show that you know the law, how it works, and how it applies to the specific facts. Do not assume because something is obvious that you should not write about it. So we covered that a little earlier, right? If it's obvious, you do write about it, but keep it simple. You do not have to use a lot of legalese and complicated structures in order to sound smart. People want the information and want you to get there succinctly. So tackling the legal issue is the most important part of a legal document. This is also referred to as the issue statement. It is usually written as a question that needs to address the main aspects of the legal problem. So no specifics yet. Necessarily, you're asking a general legal question. So you're writing a perfectly formatted issue statement. It is tricky, but while you're learning, the best style is under blank, law, blank, when blank, question mark. Again, there's more than one way to write an issue statement. So what I'm saying is learn these basics and then you can kind of start to craft it in a way that you like. So let's see how that applies. Here's some sample issue statements. The under portion is the easiest because you're stating the location or the jurisdiction. The next blank of the question refers to the crime or liability, and the final blank refers to the specific case at hand. So, for example, under Maryland law, is a landlord negligent when he hasn't replaced a broken fence for over 6 months and a wild animal came onto the property? That's really easy to understand. Now we have our issue and we have to try to solve that, right? Here's another example. Under Georgia law, can a person be convicted for breaking and entering if she was attempting to make an emergency phone call when she broke into her neighbor's apartment? Great issue statement. Now we know what some of the facts are, we know what our jurisdiction is, and so we're going to be looking for a rule to help us decide how to answer these issue statements. Rule statements require some work too. You want to write out the rule in the same neutral tone, right? Well, even if you're advocating for one side or the other, you want to try to keep it neutral at this point. Because if a judge or your professor or a client, hasn't decided which way they want to go yet, you want to know that you're not just saying things in order to advocate for your position, but that you're actually demonstrating to them legal analysis and what the rule is or should be. So only a few sentences for the rule statement. This isn't where you start to explain the law. This is a common mistake I see a lot of students do. They start just this whole paragraphs. They state the entire law and every exception and nuance. Not the time. I need a basic rule statement. And so you may have to start with the subsection of the rule or the exception of the rule because there's a lot to talk about there. And that's going to be based on what the facts trigger. Also, even if the law is unclear, write your rule in a definitive tone. Your analysis and conclusion can explain the deficiencies, and the rule may seem like a run-on sentence. That is okay. Okay, this is not where we need perfect grammar necessarily. You need good grammar. But if it's a run-on sentence, this is going to be one of those times where it can be an exception to that rule. So here are some sample rule statements that are responsive to the issue statements that we talked about earlier. So yes, a Maryland landlord is considered negligent for neglecting repairs to a fence where there was actual and constructive notice that the damage was large enough for an intruder or animal to pass through and cause harm. Okay, so that's a sample rule statement. So we know Maryland requires landlords to maintain fences, and they're required to have actual or constructive knowledge, particularly when the damage is large enough to allow an animal to come in. Okay, great. So now we start getting into the facts and deciding, did the landlord have actual or constructive knowledge? Was the hole in the fence big enough for an intruder or an animal to go in, right? And then we're going to start applying those or analyzing them. Here's the second one. No, a person facing an imminent threat of harm to herself and her loved ones cannot be considered guilty of breaking and entering when trying to escape danger and contact law enforcement. So we know if you've studied burglary, breaking and entering someone else's home is usually at nighttime, etc. Some form of burglary or trespass. But it sounds like here the rule is showing an exception to that rule. And so we're talking about, did this person face an imminent threat of harm? And was it to protect herself or loved ones? And was she trying to escape danger and contact law enforcement? So now here are the important facts we need to find to determine how to analyze these two issues. So writing the answer and analysis, you want to pick your supporting law from the same geographic location. So here you're talking about the jurisdiction really. So if we're in common law, use common law. If we're in model penal code jurisdiction, use that. If you're in Florida, use Florida law, etc. And then you also want to use other locations, rules as persuasive authority if you think the rule here is unfair or unjust or wrongly decided. You can say, hey, look at all these other jurisdictions that shows otherwise. This jurisdiction should adopt that rule, and here's why. So as a rule, criminal law cases will need a reference to a common law, model penal code, etc. Many civil law cases, especially personal injury, may not have an appropriate statute, and so you're looking at case law. Complex cases or cases with more than one issue should have subheadings for each individual legal topic or section. That's what I said earlier, like you don't want these long paragraphs, you want to break up those paragraphs, and those paragraphs will make up this particular section if we're looking at a sub-issue, as opposed to all the possible rules associated with these facts. You want to hone in on the ones that are really relevant and will help answer the legal issue as you framed it. So here is an example of using analogy or comparison. Like the defendant in Hayes who used a knife to enter the store, the client picked open the lock with a pocket knife. Unlike the landlord in Cogswell who knew of the mold growth for several weeks, the landlord in this case was only notified of mold when Mrs. Smith went to the hospital. Okay, and so that is how you're going to make this analogies, particularly with case law. Concluding your IRAC is just a summary of your legal findings. Your conclusion shouldn't be longer than a paragraph, but it should address the legal question and offer a legal ruling. Guilty, not guilty, entitled to damages, not entitled to damages, dismissed, sustained, overruled, etc. Right? Depending on what area of law and what the kind of conclusion is necessary, it should be a logical step in your analysis to draw some kind of legal conclusion or legal ruling. So here's a sample conclusion for you to look at. In Texas, a landlord will be considered negligent if he or she had actual constructive notice of mold, yet failed to take appropriate action to correct the problem. Mrs. Smith never informed Mr. Apple of the mold, nor did Mr. Apple have any reason to come and inspect her apartment. As a result, it's unlikely that Mrs. Smith will be able to recover damages from Mr. Apple, and we should decline the case. And so you can tell from the conclusion that this might have been a memo to a partner about whether or not they should even take the case to begin with. So the conclusion would look slightly different If it was a judicial order, it will look different if you were representing a defendant and saying Mrs. Apple is not entitled to damages, the court should deny any request for relief, etc. Okay, so it depends on how the facts were framed to you. Law professors like to give you, reality-based fact patterns where we say you're the judge or you're the prosecutor, you're the defense attorney, you're representing the plaintiff or defendant, etc., so that you can have this practice-oriented mindset when you are doing these questions. Do the same on exams and do the same on the bar exam. Those aren't necessarily deal breakers, but it just helps you stay focused on what you're really trying to do with your legal writing. So here's some alternatives to IRAC. You might have heard this of CRAC or CREAC, CRAC or CREAC. And the C typically refers to the conclusion and E is the explanation. So it's just drawing out those different pieces a little more. Instead of putting the explanation in your analysis, you're going to put it separately. Instead of having the conclusion only at the bottom, you have it first so that you can let people know where you're going with this, and then they'll read the rest to see how you got there. Another one I really like is called CROFDIAC. Professor Berry at Western Michigan University, Cooley Law School, uses this model. I've adopted it with my students, and basically this is CROFDIAC. So the CR stands for the condition of the rule, which means it's the trigger. What is the fact that triggers our use of a specific rule? OF stands for the operative facts. Again, we're honing in on the facts that matter, not all of them, only the relevant ones. And when you have multiple issues, you're honing in on the facts that are relevant to the issue you're discussing in that section. DI stands for deep issue. So not just the issue is whether so-and-so broke this particular law, the issue is going to be whether this particular set of facts meets a specific element, which goes to this larger issue of whether or not this person broke the law. Analysis is A, and then you have D and C and CS, and then C stands for conclusion. So we're going to dig a little more into CROFDIAC. So the condition of the rule, CR, elements, factors, etc. of the rule. And here's an example. The first element of burglary is breaking. So if you break, then you commit the first element of burglary. Again, this sounds really simple, straightforward, too obvious, but you're trying to practice building this framework so that you're always thinking that way. And the more complicated the facts get, the clearer your writing will be if you're following these kinds of formats. So for OF, operative facts, facts within the fact pattern relating to this element of the rule. So an example here is D brushed against an open door on her way into the house. So DI, deep issue. Do the operative facts pull the trigger? And here's an example. Does brushing against an open door constitute a breaking? And so if you take in criminal law, then you know there's always this discussion about what is breaking, what is entering, right? It seems obvious at first. Turn the doorknob, push the door open, walk in. Clearly breaking and entering. But here we have brushing against the door, which then leads to its open. Is that the same thing? Putting an object through the opening of the dwelling, does that count as entering even though your physical body has not gone through? So now you see what the deep issue looks like. What I talked about, we're really honing in on a particular element or a factor, depending on what type of rule we're dealing with. Analysis, this is a great place to have definitions, comparisons, and common sense. So that's what the D and the C and the CS stood for. Definitions, comparisons, and common sense. We don't want common sense to go out the door just because we became lawyers, and some people feel like they have to do that. There are times when the application of a certain rule or law seems to defy common sense, but those are the exception and not the rule, and so you just have to understand those exceptions and apply them when necessary. Here's an example of analysis using the same facts regarding breaking. So breaking means the application of any force, however slight, to gain entry. And so here's comparisons. A court found that a person had broken by turning a doorknob and pushing a door open. The same court found that a person had not broken by jumping through an opening without touching anything. And so here's an example of using common sense as part of your analysis. Quote unquote brushing against means touching, but doesn't mean moving. So it's a close call and it's hard to say. And a conclusion, again, simple, get to the point. When you're doing CROFDIAC, because so much of the time is spent on this analysis and deep issue and rule triggers, this conclusion can be even more brief. So here, the defendant did not break, so the first element is or is not met, depending on how you decide. And you should choose a side. In the analysis, we said, well, on the one hand, on the other, but we're going to want you to choose a side or else it won't be a true conclusion. So CROFDIAC helps to fill in the gaps and helps you make sure you're getting all of the issues. So for exam purposes, you want to spot all of the issues being tested. There are always multiple being tested on an exam, and on the bar exam, there are at least 19 distinctive things for which you will get points, and that is the Florida bar exam. Each one of those essays is worth 100 points. 5 of those points are typically reserved for what's called style, meaning, use proper grammar and paragraphs and sentence structure, etc. And so that leaves 19 other things to get 5 points for. They always grant points at 0, 3, 5. And so that means it's only going to be 20 things worth up to 5 points. And we know 5 of those points are dedicated to style. So that leaves 19 different issues, rules, analyses, or conclusions that the graders are looking for. You need to identify what those things are. So if you feel like you've only talked about 2 crimes and you just talked a lot about them, there's a good chance you missed a lot of issues. And so CROFDIAC will help you catch those while you're doing your issue spotting. And as you're writing, you're going to say, I spent some time on this, but there's got to be more things. If the breaking is an issue, maybe entering is also an issue, or there's another crime about whether or not it may be trespass, and does that merge into a burglary? Or if it falls short of a burglary, is it now something else? That's the kind of analysis you should be doing. So here's a CROFDIAC analysis based on the Warmke case. Warmke is the case in criminal law a lot of students study. So a woman says she dropped her newborn child by accident into a river with a strong current. The child was never recovered, and she is charged with murder and argues that they have not proven what's called the corpus delicti of the crime. So the issue here is whether the facts presented sufficient evidence to establish corpus delicti. And we know that the rule is that corpus delicti requires death plus criminal agency of the defendant. So this is a very broad issue and rule statement. Now we're going to break the rule into its component parts and analyze them separately. And now we're going to see how we use CROFDIAC to do that. So the death issue is whether Warmke's testimony that she dropped the baby in a flooded creek establishes the baby's death when no body was found. And for the criminal agency issue, whether Warmke's statements that she accidentally dropped the baby combined with big holes in her story of the events, i.e. not reporting the accident, is enough to establish criminal agency. So here we're using definitions, analogies, and common sense. As to the death issue, death means that someone has died from something other than natural causes or accident. When it comes specifically to corpus delicti, to be clear, under this rule, that's what death means. So here, Warmke admitted dropping the baby in a flooded creek. The baby cap was nearby. No body was recovered, and the current was strong. And it's unlikely that a baby could survive in that creek if dropped, right? So I'm just using common sense there. It's unlikely that a baby would survive that. For the criminal agency issue, you can argue that her story does not add up. It was an accident, but she did not tell anyone. She was looking for someone, but never made it to that person's home. She says she was dazed, but remembered to call the store to pick up her suitcase. She left her suitcase at the store inexplicably, when she went out seeking this person she was looking for while holding her baby. And the child was illegitimate, and she was concerned about the guilt and shame associated with having an illegitimate child. And we know that circumstantial evidence is admissible to help prove corpus delicti. So that's part of what we're reviewing here. And so as you can see, we are going to go on and conclude that there is enough here based on these facts to show both death of a child and criminal agency by the defendant. And as those of you who read the case know, they did find that corpus delicti was sufficiently established and then moved on to whether they can go forward with the homicide charge, and she was found guilty. And so that is IRAC in a nutshell with a couple of twists to them if you want to try to something more advanced. If you have not done regular basic IRAC yet, I would say practice that first, master it. And then when you get to your other courses, particularly constitutional law, evidence, procedure, where things are can get a lot more fuzzy and there's a lot of overlap between the different issues, you want to try to use CROFDIAC to really hone in your analysis skills and your issue spotting. Thank you for your time. I hope you were able to learn something from this presentation.